Hey, good morning, class. We're now in week 6 in the semester, and today we're going to cover some interesting topics. We've got agency, employment law, employment discrimination, and labor law. And again, as I've done in my previous videos, I'm going to give you kind of an overall approach to the chapter, but it's important to study the cases under each one of the topics because the cases give you valuable insight into the law. That being said, let's start out with Chapter 18. We'll start today with employment law. And the theme of this chapter is that employment law is important and difficult, a very difficult area of the law to study. It's important because it affects almost everyone, directly or indirectly. It is difficult because it is changing rapidly. Even now, employment law can vary dramatically from state to state. So it's important that you stay tuned. And as I do with most of the chapters, I'll give you the quote of the day. And this comes from the very famous mystery author, Earl Stanley Gardner. He created the Perry Mason character in the series of Perry Mason books. And his quote was, "I wouldn't want to live unless I could work for a living." And that's kind of my philosophy too. I think that the day you stop working is the day you stop living. So it's always important to keep things going, keep busy. And in regards to the common law, the rule was that an employee at will could be fired for a good reason. Or you could be fired for a bad reason or no reason at all. Today, a boss can no longer discharge an employee for any reason whatsoever. Don't know if I agree with that. They'll come up with a way. If they want to get rid of an employee or get rid of you, they'll figure out a way. One element of employment security is the Family and Medical Leave Act. And what the Family and Medical Leave Act, which has become really important today, or the FMLA, guarantees both men and women up to 12 weeks of unpaid leave each year for childbirth, adoption, or a serious health condition of their own, or in their immediate family. A family member is a spouse, child, or parent, but it does not include in-laws. Ethically, although the FMLA offers important protections, the time off it provides is unpaid. It's critical to understand that it's unpaid. Some cities require employers to provide paid family leave, but currently, only 11% of private sector employees are eligible for this type of time off. The federal government provides none for its own employees, not even for childbirth. The United States is the only advanced country that does not require employers to provide paid maternity leave. Should Congress modify the FMLA to require some period of paid leave for new mothers? If so, for how long? A few weeks while they recuperate from childbirth, maybe, or a few months to care for the newborn. What about paternity leave, which many countries require? And how about workers who take FMLA leave to deal with a serious illness? What do you think? Should they be paid? Well, here's some of the common law protections. And the first one regards wrongful discharge violating public policy. As a general rule, an employer may not fire an employee for a reason that violates basic social rights, duties, or responsibilities. Let me read that again. It's a very important sentence. As a general rule, an employer may not fire an employee for a reason that violates basic social rights, duties, or responsibilities. In essence, an employee may not be fired for refusing to violate the law, or let's say performing a legal duty, exercising a legal right, or supporting basic societal values. That's the key, societal values. What constitutes a societal value? In regards to refusing to violate the law, as a general rule, employees may not be discharged for refusing to break the law. Courts have protected employees who refuse to participate in an illegal price-fixing scheme, fake pollution, control records required by state law, or assist a supervisor in stealing from customers. How about performing a legal duty? Courts have consistently held that an employee may not be fired for serving on a jury. Everybody is entitled to serve on a jury, and at one time or another, you'll be called to perform jury duty. Jury duty is an important civic obligation that employers are not allowed to sabotage. How about in regard to exercising a legal right? If workers fear that making a claim for workers' comp will get them fired, then no one will file, and the whole point of the statute would be undermined. Moving along into the aspect of agency and contract law, traditionally many employees thought that only a formal signed document qualified as an employment contract. Increasingly, however, courts have been willing to enforce an employer's more casual promises, whether written or verbal. How about truth in hiring? Verbal promises made during the hiring process can be enforceable, even if not approved by the company's top executives. One case found an employee handbook creates a contract. Some employers have responded to cases like this by including provisions in their handbooks stating that it is not a contract and can be modified at any time. I repeat, it is not a contract and can be modified at any time. Generally, these provisions have been enforced. However, employers cannot have it both ways. If a handbook states that it is not a contract, then employers cannot enforce provisions favorable to them, such as required arbitration clauses. How about in how it relates to tort law? Well, workers have successfully sued their employees under the following tort theories. First one is defamation. Employers may be liable for defamation when they give false or unfavorable references about a former employee. And believe me, that happens all the time. When you're an employer or you're in a position of power, let's say head of HR, and you have to give out a reference, you have to be very, very cautious about what you say. More than half of the states, however, recognize a qualified privilege for employees who give references about former employees. And by a qualified privilege, we mean that employers are liable only for false statements that they know to be false or that are primarily motivated by ill will. In other words, if your former employee committed a crime on the presence of his old business or your business, you can tell the new employer that that occurred. But what you can't do is lie or tell any untruth motivated by ill will. What about risky workers? Do employers have an obligation to warn about risky workers? Generally, courts have held that employers do not have a legal obligation to disclose information about former employees. But in the case of violence, as I mentioned before, the courts are divided. How about intentional infliction of emotional distress? Under the tort intentional infliction of emotional distress, employers may be liable for the cruel treatment of their workers. Not may be liable, they will be liable. And then what about whistleblowing? When you read about that employee who blows the whistle in a large corporation, well, no one likes, to be accused of wrongdoing, even if, or perhaps especially if, the accusations aren't true. This is exactly what whistleblowers do. They're employees who disclose illegal behavior on the part of their employer. Under the Dodd-Frank Act, anyone who provides information to the government about violations of securities or commodities law is entitled to a payout from 10 to 30%. Let me repeat that, 10 to 30% of whatever award the government receives, provided that the award tops $1 million. If a company retaliates against tipsters, they are entitled to reinstatement, double back pay, and attorney's fees. In 1970, Congress passed the Occupational Safety and Health Act, or OSHA, something we hear all the time at work. Does it violate OSHA? And they passed that to ensure safe working conditions. To this day, they follow it very closely, and in most companies, they have all the OSHA rules laid out when you walk into the break room or something like that. they also have all the labor laws broken out as well. You might ask, what about employee privacy? How much privacy do you feel that you're entitled to? The line between home and workplace often blurs. Employees respond to customers' emails 24/7, while their behavior at home, say drug use, can have an impact on their employer. This section deals with the worker freedom, the right to personal lifestyle choices, and to the public expression of opinions about the workplace. Off-duty activities. In the absence of a specific law to the contrary, employers do have the right to fire workers for off-duty contract. And one of the things I tell my students in all the classes I teach, you have to remember somebody's always watching. In today's digital age, everybody gets spied on. So you got to be very careful, in particular, what you post on social media. The other thing is, when you go in for an interview, the first thing the interviewer, in other words, the company, does after you leave, is they'll see if they can obtain additional information on you on social media. So again, exercise extreme caution on what you post, particularly in regards to social media. How about lie detector tests? Under the Employee Polygraph Protection Act of 1988, employers may not require or even suggest that an employee or job candidate submit to a lie detector test except as part of an ongoing investigation into crimes that may have occurred. If you get a government job, it is one of the requirements, particularly if you're handling a certain level of security, that periodically they will give you a lie detector test. You agree to that as one of the terms and conditions of your hiring. What about guns? Employers have the right to prohibit guns in the workplace, but in almost half the states, bring your gun to work laws prevent companies from banning firearms in the parking lot. Again, you can't have guns in the workplace, but in a lot of states, you cannot ban employees from carrying guns in their cars or ban them in the parking lot. We already talked a little bit about workforce safety, and under OSHA, they wanted to ensure safe working conditions. And under OSHA, employers are under a general obligation to keep their workplace free from hazards that could cause serious harm to employees. Employers must comply with specific health and safety standards. And employers must keep records of all workplace injuries and accidents. The Occupational Safety and Health Administration may inspect workplaces to ensure that they're safe. OSHA may assess fines for violations and order employers to correct unsafe conditions. Congress and the states have also enacted laws that provide employees with a measure of financial security. All the laws in this section were created by statute, not by the courts. Under the Fair Labor Standards Act, minimum wage and child labor, this passed in 1938. This act regulates wages and limits child labor nationally. And back at the turn of the last century, child employment or child labor was not uncommon. And even today, in a lot of areas in Asia and in China in particular, a lot of companies employ child labor, which in my mind is tantamount to slave labor. But back in 1938, the FLSA regulated wages and limited child labor nationally. It provides that hourly workers must be paid a minimum of $7.25 per hour, plus time and a half for any hours over 40 in 1 week. These wage provisions do not apply to salaried workers such as managerial, administrative, or professional staff. And we've recently seen quite an uproar about employees of Amazon, where they're working on 12 to 16 hours. So they just gave them a pay raise across the board, but they eliminated a lot of overtime. So you have to ask yourself, is that really a pay raise? Are the conditions the same? I hate to say it, but I think they are. The FLSA also prohibits oppressive child labor, which means that children under 14 may only work in agriculture and entertainment. Again, that's farming and in the entertainment industry. 14 and 15-year-olds are permitted to work limited hours after school in non-hazardous jobs. 16 and 17-year-olds may work unlimited hours in non-hazardous jobs. You also now have workers' compensation, and those statutes ensure that employees receive payment for injuries occurred at work. Under the Affordable Care Act, employees with more than 50 full-time employees must pay a penalty if they do not provide basic health insurance. Under the Consolidated Omnibus Budget Reconciliation Act, COBRA, former employees must be allowed to continue their health coverage for 18 months after leaving their job. And then the Social Security system, which began in 1935 during the depths of the Great Depression, was created to provide a basic safety net for the elderly and the ill and the unemployed. Currently, the Social Security system pays benefits to workers who are retired, disabled, or temporarily unemployed, and to the spouses and children of disabled or deceased workers. It also provides medical insurance to the retired and disabled. The Social Security program is financed through taxes on wages. In other words, it's removed from each of your paychecks that is paid by employers, employees, and the self-employed. Moving along, let's move on to Chapter 19. Let's talk about some things. First of all, let's look at, and Chapter 19 involves employment discrimination. Let's talk about kind of a brief overview of employment discrimination. And the theme of this chapter is the story of how the United States has traveled a long and bumpy road towards equality of opportunities in the workplace. Under the Equal Pay Act of 1963, the employee may not be paid a lesser rate than employees of the opposite sex for equal work. Equal work means tasks that require equal skill, effort, and responsibility under similar working conditions. That's the Equal Pay Act of 1963. Moving on to Title VII of the Civil Rights Act of 1964, under this title, it is illegal for employers with 15 or more employees to discriminate on the basis of race, color, religion, sex, or national origin. Discrimination under the Title VII applies to every aspect of the employment process, from job ads to post-employment references, and includes hiring, firing, promoting, placement, wages, benefits, and working conditions of anyone who is in one or more of the so-called protected categories under the statute. And what you have to prove is what we call disparate or disparate treatment. To prove a disparate treatment case, the plaintiff must show that she was treated less favorably than others because of her sex, race, color, religion, or national origin. Note that the burden of proof is on the plaintiff. She must prove that the employer intentionally discriminated, but this motive can be inferred from the mere fact of differences in treatment. Let's go through the steps. The steps required to prove disparate treatment cases are: step 1. The plaintiff presents evidence that A, he belongs to a protected category under Title VII. B, he was treated differently from other similar people who are not protected under Title VII. If the plaintiff can show these facts, he has made what they call a prima facie case. The plaintiff is not required to prove discrimination. He need only create a presumption that discrimination occurred. Step number 2, the defendant must present evidence that its decision was based on legitimate, non-discriminatory reasons. To win, the plaintiff must now prove that the employer intentionally discriminated. She may do so either by showing 1, the reasons offered were simply a pretext, or 2, that a discriminatory intent is more likely than not. What about disparate impact? Well, disparate impact applies if the employer has a rule that on its face, say, is not discriminatory, but in practice excludes way too many people in a protected group. Can't do that. And we hear a lot today about a hostile work environment. And whenever I hear this, I think, just about every work environment's hostile. But I think they look at the severity of it. And employers who violate Title VII, if they permit a work environment that is so hostile towards people in a protected category that it affects or impacts their ability to work, this rule applies whether the hostility is based on race, color, religion, sex, or national origin. This concept of hostile environment first arose in the context of sexual harassment. I think everyone has heard of sexual harassment, but few people know exactly what it is. Sexual harassment involves unwelcome sexual advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature. There are two major categories of sexual harassment. One, quid pro quo, which means you scratch my back, I scratch yours, or two, a hostile work environment. Noted for the Latin phrase that means one thing in return for another, that's quid pro quo, for those of you who have studied Latin or have not studied Latin, that harassment occurs if any aspect of the job is made contingent upon sexual activity. Offensive jokes, intrusive comments about clothes or body parts, and public displays of pornographic pictures can create a hostile environment. These offensive remarks can be conveyed through any form of communication, including texting, emailing, and in person. So if you start to do something and you think, wait a minute, this isn't right, don't do it. Always trust your intellect and your common sense. Title VII also prohibits employers from retaliating against workers who oppose discrimination. Bring a claim under the statute or take part in an investigation or hearing. I'm sorry, let me rephrase that. That was a little confusing. Title VII also prohibits employers from retaliating against workers who oppose discrimination, bring a claim under the statute, or take part in an investigation or hearing. Retaliation means that the employer has done something that would deter a reasonable worker from complaining about discrimination. Also, employers cannot discriminate against a worker because of his religious beliefs. In addition, employers must make reasonable accommodation for a worker's religious practices unless the request would cause undue hardship on the business. And the key phrase there is undue hardship. It can't just be a hardship, it has to be an undue hardship. How about family responsibility discrimination? In various studies, participants ranked mothers as less qualified than other employees and fathers as most desirable, even when their credentials are exactly the same. Increasingly, courts have held that parenthood is a protected category under Title VII. For example, under Dawn Galena, an associate at the Mintz-Levin law firm, revealed to her boss that she had a young child. He began to treat her differently from her male colleagues and spoke to her about the commitment differential between men and women. The court ruled that her belief of illegal discrimination was reasonable. Neither Title VII or any other federal statute protects against discrimination based on sexual orientation, in other words, being gay. In addition, almost half the states and hundreds of cities have statutes that prohibit discrimination based on sexual orientation. The Equal Opportunity Commission, or the EEOC, ruled that discriminating against someone for being transgender is a violation of Title VII. What are some of the defenses to the charges of discrimination? Well, under Title VII, the defendant has 4 possible defenses, the first of which is merit. A defendant is not liable if he shows that the person he favored was the most qualified for the job. Number 2 is seniority. A legitimate seniority system is legal even if it perpetuates past discrimination. Number 3, bona fide occupational qualification. An employer is permitted to establish discriminatory job requirements if they are essential to the position in question. Only religion, sex, or national origin can be a bona fide occupational qualification, never race or color. And affirmative action, the number 4 item. Affirmative action is not required by Title VII, nor is it prohibited. How about if someone becomes pregnant? Well, you have the Pregnancy Discrimination Act. And under that act, an employer may not fire, refuse to hire, or fail to promote a woman because she is pregnant. The act also protects a woman's right to terminate a pregnancy. And finally, you have the Age Discrimination in Employment Act. And this is probably the single most discriminatory factor that I find today. In my experience, I haven't found a lot of businesses that discriminate against people for their gender, race, you name it. But today there's a horrific amount of what we call age discrimination. And it's unsatisfactory. Under the Age Discrimination in Employment Act, or the ADEA, employers may not fire, refuse to hire, fail to promote, or otherwise reduce a person's employment opportunities because he is 40 or older. Nor may an employer require workers to retire at a certain age. This retirement rule does not apply to police and top-level corporate executives. How about the Americans with Disabilities Act? We hear that all the time. And the ADA prohibits employers from discriminating on the basis of disability. And under this, a disabled person is someone with a physical or mental impairment that substantially limits a major life activity or the operation of a major bodily function. Or B, number 2, someone who is regarded as having such an impairment. An employer may not refuse to hire or promote a disabled person so long as she can, with reasonable accommodation, perform the essential functions of the job. Let me read that again. Employer may not refuse to hire or promote a disabled person so long as she can, with reasonable accommodation, perform the essential functions of the job. An accommodation is unreasonable if it would create undue hardship for the employer. And again, we see this term of undue hardship. And that's where the law really breaks down, because you have to define what's an undue hardship. Then we have the Genetic Information Non-Discrimination Act. That's a mouthful. Let me give it to you one more time. The Genetic Information Non-Discrimination Act. Suppose you want to promote somebody to Chief Financial Officer, but you know that her mother and sister both died young of, say, breast cancer. Is it legal to consider that information in making a decision? Not since Congress passed the Genetic Information Non-Discrimination Act, or GINA. Under GINA, employers may not require genetic testing or use information about genetic makeup or family medical history as a factor in hiring, firing, or promoting employees. What about hiring practices? The hiring process is an easy place for employers to go wrong. Believe me, I know that firsthand. Here are some of the pitfalls to avoid. In interviews, be very careful what you say. Most interviewers would know better than Delta Airlines interviewers who allegedly asked applicants about their sexual preference, birth control methods, and abortion history. Can you believe that? That actually happened with Delta Airlines. Social media. All employers now rely on social media as part of the hiring process. And again, I can tell you as a fact they do. The first thing we do at the various companies I've either run, owned, or started, after we interview an employee, is we go to their social media site. We want to find out as much as we can. And that's basically because the average hire in a small to medium business costs anywhere from $4,000 to $8,000. These searches sometimes reveal information that is illegal for employers to act on, such as age, religion, pregnancy, or illness, yet sometimes they do. It's publicly available information. If it's open to the public, anybody can look at it. To prevent this type of liabilities, some employers keep the role of cyber vetting separate from that of hiring. A handful of states now prohibit employers from asking for social media passwords, and many others have such legislation pending. And again, don't put anything that will hold you in a negative light on your social media. Be extremely cautious. So that pretty much wraps it up for that chapter. Let's move on to the next chapter. And finally, let's move on to chapter 20. And chapter 20 deals primarily with labor law. And let's get a little bit of an overview and theme on chapter 20. Many decades after Congress guaranteed important labor rights, management and workers in many industries still clash over the old issues of union organizing, collective bargaining, and concerted action. And let me give you a couple of quotes from the day, or quotes of the day. Without the power of the industrial union behind it, democracy can only enter the state as the victim enters the gullet of the serpent. And that came from a very famous Irish labor leader back in the 1800s, James Connolly. And then we have this from H.L. Mencken, an American journalist. Unionism seldom, if ever, uses such power as it has to ensure better work. Almost always, it devotes a large part of that power to safeguarding bad work. That's an issue we run into today. A lot of people, and this professor included, feel that the unions have kind of outlived their usefulness. If you study history back in the early 1900s and the late 1800s, child labor, slave labor was very, very common, and people worked in horrible working conditions. And so there was a true need for a union. But today, with having, I think, less than 10% of the workforce in unions, one of the situations the unions have found themselves in is that the industries that they've been entrenched in, the United States is no longer competitive. We saw this in the steel industry, the shipbuilding industry, and we have it in the automotive industry. So my personal opinion is they've kind of outlived their usefulness. But we should go on and take an objective look at the chapter. In 1932, Congress passed the Norris-LaGuardia Act, which prohibited federal court injunctions in non-violent labor disputes. By taking away the injunction remedy, Congress was declaring that workers should be permitted to organize unions and to use their collective power to achieve legitimate economic ends. In 1935, Congress passed the Wagner Act, generally known as the National Labor Relations Act. And a lot of times you'll hear about the National Labor Relations Board, the NLRA. The NLRA is the most important of all labor laws. A fundamental aim of the NLRA is the establishment and maintenance of industrial peace to preserve the flow of commerce. The NLRA ensures the right of workers to form unions and encourages management and unions to bargain collectively and productively. Let me say that again. To bargain collectively and productively. Section 8 of the NLRA prohibits employers from engaging in the following unfair labor practices. There are 4 of them. Let me go over each of them right now. First of all, interfering with union organizing efforts. You cannot do that. Dominating or interfering with any union. Can't do that. Discriminating against a union member. Or 4th, refusing to bargain collectively with a union. Let me kind of give you an example, and this kind of goes back to what I said about conditions in the last century. We tend to assume that the nightmarish working conditions of the 19th century, which did so much to foster the union movement, are outdated. The reality is that in some industries, they still abound. And I already mentioned working conditions in countries like China, Korea, and Malaysia. Some of the most severely exploited workers are illegal immigrants. A United States District Court sentenced factory operators from El Monte, California to several years in prison for running a clothing sweatshop so oppressive its workers were virtual slaves. Laborers lived and worked in a compound surrounded with spike fences and razor wire. Almost sounds to me like it was more of a concentration camp. The workers were primarily impoverished women from rural Thailand who were tricked into coming into the United States with promises of decent work. Once inside the compound, they were never allowed out under threat of violence against themselves or violence against their families back in Thailand. The Labor Department concluded a 6-month investigation of a Maine chicken farm by fining the farm's owner $3.6 million, one of the largest penalties the department has ever assessed. The DeCoster farm has annual sales of $40 million, providing brown eggs to many New England supermarkets. The farm's 3.5 million chickens produce 12 to 14 million eggs per week. Farm workers, mostly from Mexico and Central America, were forced to live in cramped company trailers, sometimes jammed up to 17 per unit. The trailers were filthy and often lacked water and sanitation. The farm forced laborers to operate dangerous, unguarded machinery without protective gear, exposed them to filth and undisposed human waste, and refused medical attention when the workers suffered serious on-job injuries. The impoverished laborers often worked as many as 22 hours a day, receiving only partial payment for their efforts. The majority were desperate to keep their jobs so that they could continue to send money home to their families. Organized labor is in a flux in the United States. In the 1950s, approximately 25% of workers belonged to a union. Today, it's only about 11%. That is the lowest level since 1916. So it's the lowest level in 102 years. Even more startling, membership in private sector unions has declined from 35% in the 1950s to only 6.6% today. That's a heck of a decline. This decline in strength reduces union bargaining power. Thus, the auto unions agreed to a 2-tiered structure that pays new workers little more than half the wages of long-term employees. All of these factors have contributed to stagnation in pay for the bottom half of wage earners, even as their productivity has increased dramatically. So, I think that just about covers it for this week. We've gone over the 4 chapters: agency, employment law, employment discrimination, and the labor law. And again, I encourage you, and it's important to read the various cases because they give you a good example and sometimes a better definition of the law. But that's it for week 6. Have a great week. Continue to do well, and I will see you next time.